The last topic regarding conflicts of interest is Rule of Professional Conduct 1.10, officially called Imputation of Conflicts of Interest, but I think it more frequently is called in the real world imputed disqualification. So be familiar with that term as well, imputed disqualification. This rule is giving us guidance when we have the situation where one attorney in the firm has a conflict. Does that mean the other attorneys in the firm have a conflict as well? So, starting out, the general rule is if it is a conflict for one, it is a conflict for all. And so, under the first part of Rule 1.10, that's basically what it is saying. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by the earlier rules that you've already covered in these materials. So that is the very succinct rule. If it is a conflict for one, it is a conflict for all. There are exceptions to this, so it is important to understand the exceptions, but it's also important to understand that they are, in fact, exceptions. The rule is if it's a conflict for one, it's a conflict for all. So if we're all attorneys in a law firm, and a client contacts our office, a prospective client contacts our office for assistance. If I have a professional conflict with that client because of another case I have worked on, another client that I've had, that means nobody in the office can take that case. I find this to be one of the more misunderstood or confusing aspects of conflicts. The idea that, oh, if it's a conflict for me, that's okay. My colleague can just take the case. And that is not what the rule is. So if we are all in the firm, we're all working there already, prospective client walks in, if it is a professional conflict, for me, it is a professional conflict for everyone in the firm, and no attorney in the firm can handle the case. And that is what the first part of Rule 1.10A is stating. It does make give an exception if it's a personal interest of the lawyer as opposed to professional conflict, and does not present a significant risk of materially limiting the representation of the client. Then it may be allowed, unless, again, it is not permitted by the later parts of this particular rule. That's a pretty narrow exception because most of our conflicts are going to be professional ones, not personal ones. But what the firm would have to do in that situation is be able to provide assurance, should they be challenged on it, that this is a personal conflict of an attorney. They're not going to be working on the case, and it doesn't present a significant risk of materially limiting the representation of the client. Keep in mind that if we are all working in a law firm, we all, in theory, have access to the case. The firm is representing the client, and anyone working in that firm can work on that case. So even though, as attorneys, we tend to handle our own cases, it is not unusual for other attorneys to have to step in and take care of things. Just like you may be working for a particular attorney, it wouldn't be unusual, though, for you to have to help out another attorney. So as long as we are all in the firm, if it's a conflict for one, a professional conflict for one, it is a conflict for all of us, and we cannot take that case. And again, keep in mind, conflict checks should be done before the client ever gets back in to see the attorney or the paralegal for the initial interview, and they should be conflicted out so we don't have to deal with that. But if you ever have a situation come up, go to your attorney, let them know the situation, let them make the call. Okay, so the next part of the rule is dealing with the situation of what happens when a new attorney or new paralegal joins a firm and that new attorney or paralegal brings the conflict with them. So I'm working in a firm, I'm representing, client B, and you are now hired by the firm, and it turns out at your previous job, that firm represented opposing party. So we didn't have a conflict when I took the case, but now because you are hired, we have a conflict. That is what Part B of this rule is dealing with. And this is why it's important for you to be aware of the cases that you've worked on, but also to completely disclose to prospective employers where you have worked, because they can easily look up in their database and see where opposing parties are represented and screen you out of those cases. And that's what Part B is talking about. So when a lawyer becomes associated with a firm, the firm may not knowingly represent a person in the same or a substantially related matter in which that lawyer or that lawyer's previous firm had represented a client whose interests are materially adverse to our client and about whom the new hire has acquired information that's protected by confidentiality. Unless. So I'm going to stop there because that's a lot of words and I feel it's a little confusing. So I want to make sure everybody understands it. So again, Part B is dealing with the situation where I am in a firm, you are the new hire. You come into our firm and you or someone else in your firm or your firm as a whole has represented an opposing party of ours. That is the situation. So you are bringing the conflict with you. Sadly, you are sometimes referred to as the tainted person in that situation. It's kind of a horrible word, but it just means that you have a conflict of interest. So should that be the case, the first part of this rule is saying we can't continue representing our client in that case once you are hired unless, part one, the disqualified lawyer is screened from any participation in the matter, including not receiving any part of the fee from that case. So that is the first part, the screen. So this gets called a variety of things, and they talk about it in the textbook. I think an ethical screen is probably the easiest thing to call it, but it's also called a cone of silence, which just truly makes me think of dogs when they have to wear the cones around their head so they don't, pull out their stitches or something. So I don't like that term. It's also called an ethical wall, a Chinese wall. They all mean the exact same thing. It means that this new hire who's coming in with the conflict, the disqualified, the conflicted, the tainted attorney or paralegal, as the case may be, it could also apply to secretaries as well, anybody in that firm, that they are screened from participation in that case, including not being paid any fee from it. And so if year-end bonuses are given because of a successful case, you can't get a bonus from that case because you are being screened from it. So let's talk about what an appropriate screen would be. So normally we would just kind of brainstorm this in class together. So I'm going to instead just give you a list of possible ways of doing it. It's not exhaustive. It depends on the firm. It depends on the creativity of the firm. But what is important is should the firm be challenged, they can support that an ethical screen was in place and it was effective. So types of screens. One would be making sure that the disqualified person has no contact with the actual case file. So in the old days, if it was a paper file, you put a sticker on the top of it and it would just clarify that attorney so-and-so, paralegal so-and-so, not to have access to this case. You should be able to do the same thing with electronic files, whether a notice pops up that a certain attorney or paralegal cannot have access to it, or whether the system would allow for them just to not even be able to access it. That would be great as well. Meetings. When this case is discussed at meetings, and attorneys regularly have case review meetings, the disqualified or tainted or conflicted attorney or paralegal or secretary would have to leave the meeting. They cannot have anything to do with it. If you can physically separate them, that can be helpful, but I don't know how many firms are really set up to just kind of, I hate to use the word quarantine in light of everything that's happening in our world right now, but I don't know if it's possible to literally quarantine someone away from everyone else. Another thing that needs to be done is everybody needs to be aware that this disqualified person cannot have any access or any communication with anyone regarding this case, because I could be talking to my coworker about a case and you might join us. I have to stop talking about that case. I need to be aware of the screen. So sending out an email notice to everybody in the firm to just make sure everybody's aware that new hire can have nothing to do with this case is also a really important thing, because it's not just the new hire that has to be aware of it, it's all of us that work with them. So those are just some types of things that we can do in the office, making sure everyone's aware, tagging files. These should be in place before the new hire ever starts, so everybody is aware of it. I think the book talks about having, the new hire sign an agreement, which is fine, but it's not a necessary component. That would just protect the firm to insofar as the attorney or paralegal or secretary knew that they were being screened. But whatever steps the firm needs to take, they need to be put in place, they need to be followed, and everyone needs to be made aware of them. That would be an appropriate ethical screen. So the good news is you can change jobs. You can be hired by a new firm, even a firm that is opposing party in some of your previous firm's cases. You can still be hired there. You will just need to be screened from those cases. And it really doesn't make a difference how closely you may have worked on those cases. You may not really have any real knowledge about those cases. The best action for the new firm to take would be to screen you from those. Then the last thing that has to happen is written notice has to be given to our client to let them know of the fact that we have a disqualified attorney or paralegal or secretary, but that they're going to have nothing to do with your case. And notice that it is not getting permission from the client. We're not getting a waiver from the client. So this is not that situation that was talked about earlier about potential waivable conflicts. This rule just requires us to give written notice to the client. So that's what we would do. We would send them a letter, an email, and we would reassure them that this person, even though they had previously worked at opposing counsel's office, that they will have nothing to do with this particular case. And so that is frequently a misinterpretation of the rule that I see students making, is they think the client has to approve of this. The client does not have to approve of our hiring decisions. The client does not have to approve of our screening. The client has to be given notice of the hiring of the disqualified person. They have to be given assurances the person will be screened, and the client does have the right to challenge the screening if it believes it is not effective. But that's the client's role in this. They do not have the right to come in and deny us the right to hire someone new. Okay. So just a side note to this, because some firms will do this. They aren't absolutely required to do it. But some firms, when you were hired, they might have you sit down and just look at all the names of clients and opposing parties to determine if you have any personal conflicts as well. If you know an existing client of the firm, that's not technically a conflict. Okay. If you know an opposing party of one of the cases, that might be a conflict, especially if you have any confidential information from that opposing party relevant to this case. But technically, it is not a conflict for you to know someone that your firm is representing. In fact, you can refer people to your firm. It is not, in fact, a conflict. However, it can sometimes be an awkward situation, and sometimes attorneys would prefer you not to work on those cases. If that is the situation, that is up to that firm and you will want to abide by it. But it's not a conflict per se. And I will give you a quick example. Former student was hired by a personal injury firm. Attorney had her sit down, go through the list of clients and opposing parties, and she did know a couple of opposing parties who actually had been her instructors here at HAC. And the attorney said, we're not going to let you work on those cases. It was not technically a conflict, but it was a precaution to take because of the changing roles that people played. And so just